challenging refusals, creating change, why Lebanese applicants must know their review rights. Lebanese applicants have rights. A visa refusal from the Australian Department of Home Affairs can be upsetting, but it is not always the end of the process. Many refusals can be reviewed, giving applicants the opportunity to challenge a decision they believe is incorrect or unfair. The department makes the first decision on a visa application. If review rights exist, the Administrative Review Tribunal, RT, can independently reconsider that decision. The tribunal is separate from the department and conducts an independent merits review, looking at the facts, evidence, and law to determine the correct or preferable decision. A refusal does not automatically mean the department was right. Sometimes a decision may result from misunderstanding the applicant's circumstances, insufficient evidence, an incorrect interpretation of the Migration Act or migration regulations, or failure to properly consider important information. This is why review rights exist. At the tribunal, applicants may have the opportunity to provide additional evidence, explain their circumstances more clearly, respond to concerns raised by the department, and, where appropriate, present witness evidence. The tribunal can reconsider the entire case rather than simply deciding whether the department made a legal mistake. For many applicants, the tribunal hearing is a formal opportunity to be heard. The applicant may answer questions, explain their case, address concerns, and argue why the refusal should not stand. This process can have a significant impact on a person's future, family, education, career, or ability to remain in Australia. Applicants should not automatically accept a refusal without understanding their rights. If you believe your evidence was misunderstood, your circumstances were not properly considered, or the law was applied incorrectly, you should seek professional advice to determine whether review rights are available. The key difference between the department and the tribunal is important. The department makes the initial administrative decision based on the application before it. The tribunal independently reviews that decision and may consider new evidence, additional information, and legal arguments before deciding whether the refusal should be affirmed, varied, set aside, or remitted for reconsideration. Issues that may arise in review proceedings include incorrect interpretation of visa criteria, misunderstanding of study intentions, financial evidence, employment history, relationship evidence, protection claims, family violence evidence, public interest criteria, procedural fairness, or other legal requirements. Every case is different, and not every refusal can be overturned, but many deserve careful assessment. One of the most important factors is time. Migration review deadlines are strict, and missing a deadline can permanently remove the opportunity to seek review. Anyone who receives a refusal should immediately determine whether the decision is reviewable, identify the applicable deadline, gather supporting evidence, and obtain legal advice as soon as possible. Behind every visa refusal is a real person. It may involve a family facing separation, a student whose education is at risk, a worker whose career is affected, or someone who fears returning to their home country. The tribunal process exists to ensure applicants have the opportunity to present their case before an independent decision maker. Standing up for your legal rights is not improper. Challenging a decision through the lawful review process is an important safeguard built into Australia's migration system. Where review rights exist, applicants are entitled to use them. The most important message is simple. Asterisk, do not assume a refusal is the final outcome. Asterisk, understand why the application was refused. Asterisk, check whether review rights are available. Asterisk, act before the appeal deadline expires. Asterisk, seek professional advice where appropriate. Sometimes the difference between accepting a refusal and properly challenging it can change everything. A department refusal is the first decision, not always the final one. Understanding your rights may provide the opportunity to correct errors, present stronger evidence, and achieve a fair outcome.